Lower courts are required to follow the rulings of higher courts. That's not opinion. That's the foundation of the rule of law. But tonight, we ask a deeper and far more uncomfortable question. What happens when legal precedent meets political pressure? What happens when a magistrate's decision carries international consequences? And what happens when the public begins to question whether justice is truly independent? Because what is unfolding right now in Guyana is not just another extradition case. It is a stress test of judicial independence, a test of constitutional due process, and a test of public confidence in the courts. At the center of this storm are Azruddin Muhammad and his father, Nazar Muhammad, and a magistrate whose ruling could echo through Guyana's legal system for years to come. Stay with us, because what happens next could define a precedent, not just follow one. Channel Intro. Welcome to Global Sightline, where law, power, and accountability collide. Before we begin, a quick reminder. Only subscribers can comment on this video. So if you care about justice, transparency, and the future of Guyana's legal system, hit subscribe now and make sure your voice is part of this discussion. Setting the stage. Why this case matters. On the surface, this appears straightforward. The United States has requested the extradition of two Guyanese nationals. Guyana, under international treaties and domestic law, is processing that request. This is not unusual. But what makes this case different is the combination of constitutional challenges raised by the defense, public statements by senior government officials, the involvement of precedent-setting rulings, and the final authority resting outside the courtroom altogether. Together, these factors have transformed a legal process into a national conversation. And that conversation centers on one core principle. Can a magistrate decide freely, without pressure, expectation, or influence? WHO holds the power in extradition? Let's clear up a major misconception right away. Many people assume that courts have the final say in extradition matters. They do not. Under Guyanese law, the court's role is to assess the legal sufficiency of the request, determine whether evidence meets the threshold, address constitutional and procedural objections. But the final certification of extradition lies with the Minister of Home Affairs. That means, even if a court commits an individual for extradition, the ultimate decision is still executive, not judicial. This separation of roles is legal, but it also raises serious questions about checks and balances. And that's why judicial independence at the magistrate level becomes so critical. The magistrate at the center. The magistrate presiding over this case is Judy Lachman. She has not spoken publicly. She has not indicated how she will rule. And that silence is exactly what judicial independence requires. Yet despite that, pressure is building. Not in the form of direct orders. Not in the form of written instructions. But in something far more subtle, and arguably more dangerous. Subtle pressure versus direct interference. Judicial interference is easy to identify when it is blatant. If a government official were to say, "You must rule this way," that would be a constitutional crisis. But modern influence rarely works that way. Instead, it arrives through public commentary, legal framing, language that narrows perceived options, statements that imply inevitability. And that brings us to the comments made by Attorney General Anil Nandlall. The Attorney General's statements. While updating the nation, the Attorney General outlined what he described as the magistrate's options. According to him, the magistrate may refer constitutional questions to the High Court, or dismiss those questions as frivolous and vexatious, and proceed with committal. Now, legally speaking, this framework exists. But here's the issue. Words matter. When a senior legal officer publicly characterizes defense arguments as potentially frivolous and vexatious, it sends a signal, intentional or not. Those words imply the issues are already settled. The arguments lack merit. The outcome is largely predetermined. And that is where perception becomes reality. Plain language versus legal jargon. Let's pause for a moment. Frivolous and vexatious are not everyday words. To the average citizen, they sound authoritative but unclear. In simple terms, they mean a waste of the court's time. Arguments without serious legal foundation. But should constitutional concerns ever be dismissed so lightly, especially in a case with international consequences? And wouldn't public confidence be stronger if legal explanations were delivered in clear, plain language? Because when citizens don't understand the law, they don't trust the process. The doctrine of precedent. The Attorney General also emphasized the doctrine of precedent, known as stare decisis. This doctrine requires lower courts to follow binding decisions of higher courts. That principle exists for good reason: consistency, stability, predictability. And yes, magistrates are bound by superior court rulings. But precedent is not a cage. Courts around the world recognize that every case turns on its own facts. Legal principles must be applied, not copied mechanically. There are legitimate moments when facts differ. Circumstances evolve. Justice demands closer scrutiny. And extradition cases, by their nature, carry life-altering consequences. Justice versus obligation. So here is the heart of the debate. Should a magistrate follow precedent simply because it exists? Or examine whether applying that precedent would produce justice in this specific case? This is not rebellion against the law. This is judicial responsibility. True independence does not reject precedent, but neither does it abandon judgment. The risk of perceived influence. When legal explanations sound like expectations, when options sound limited, when outcomes feel assumed, public trust erodes. Even if no interference exists, the appearance of pressure is enough to raise concern. And once public confidence in the courts weakens, the damage lasts far longer than any single case. Why this case is a test? This case is not just about extradition. It is about whether courts can operate without expectation. Whether magistrates can rule without fear. Whether justice is seen to be done, not just done. Guyana's legal system is being watched, not only locally but internationally. Final questions to the audience. So we leave you with these questions. Should magistrates strictly follow past rulings, or judge every case on its own facts? Where is the line between legal explanation and subtle pressure? And how do we protect judicial independence in politically sensitive cases? Let us know where you stand in the comments. Subscribe so your voice is heard. This is Global Sightline, where law, power, and accountability collide.